All right, welcome to the I Got Fired show, for a show for people who've been fired or afraid they might be. We've got with us again today Rob Porter, who is an attorney in our office, and we're going to be continuing our series about employment rights for federal workers. The last show we did, we talked about performance improvement plans and PIPs and how those play out in the federal sector, which can be quite different than in the public sector. Today, we are going to talk about how workplace misconduct accusations in the federal workplace, how those play out and what those investigations look like and the different statutory schemes that they are under. So welcome again, Rob.
Thank you. Pleasure to be here.
So tell us about, so there are two statutes that apply here. Tell us just a broad overview of what they are and which baskets the different charges go in.
Okay, so there's two basic laws that govern how government agencies, federal government agencies, can take an adverse action or a punitive action against an employee. So Title V, Chapter 43, and Chapter 75. Those are the two. And so the PIPs that we talked about last time are a requirement of the process outlined in Chapter 43. Chapter 43 governs poor performance for critical elements, for an employee's critical elements that are outlined in their performance plan. On the other hand, Chapter 75 governs misconduct or poor performance that harms the efficiency of the service. So an agency can take an action under 75 without going through that PIP process that we talked about last time.
And what are the pros and cons? Like, why wouldn't an agency always go under Chapter 75 rather than going through the PIP process?
So why wouldn't they always? So they often do like to go through that process because they don't have to issue a PIP and go through all of that. One difference between Chapter 75 and Chapter 43 is that 75 and 43 have different standards. The agency has to meet a slightly higher burden of proof. Under 75, without the PIP, they have to meet the preponderance of the evidence standard, and that means that basically the employee, more likely than not, committed the act of misconduct or was a poor performer. Whereas under 43, it's a lower standard of substantial evidence, which means that a reasonable person could find that the employee was a poor performer. Even if maybe another reasonable person could disagree, you just need, a reasonable person could find that that's the case. Whereas preponderance of evidence means more likely than not.
So I guess the other category of wrongdoing or alleged wrongdoing in the federal sector are what would you call a workplace misconduct kind of claim, right? So those would not be necessarily related to performance, but might include, for instance, out of work activity. For instance, if you're arrested or things like that. And am I correct? Those would have to be brought under 75. Those cannot be brought under 45.
That's right. 75, it has to, any misconduct claim would fall under 75. Chapter 43 only covers poor performance in a critical element. Another reason that the agency might like 43 is that if they can show that they jumped through all the hoops, they're basically done. If it's appealed to the MSPB, the administrative judge is going to say, did you check all the boxes? Did you give them a performance improvement plan? Tell them what their standards were, so on and so forth. And if the agency could do that, it's difficult for the employee to prevail there. Whereas, it would also be difficult under Chapter 75, but as I said, the standard's a little different. There's a slightly better chance of success. But
a chance of success by the employee or the employer?
By the employee, I would say.
Okay.
That is, if the agency can show that it jumped through all those hoops, and sometimes they get tripped up on that. So it's a judgment call by the agency as to which one to pursue, as we discussed before. But yes, for misconduct, which could be an action outside of work, or for example, committing a crime or a misdemeanor, if your agency finds out about that, or things that happen during work. For example, if you are accused of lack of candor during an official investigation, if you're accused of, sexual harassment, for example, or accused of, any kind of violation of the code of conduct, stealing, anything like that would be
That are not
something that falls under Chapter 75.
Right, and those are not necessarily performance related. Those are wrongful conduct in the workplace. Like, it's not like if you're coming to work late all the time, then one could argue that that is an essential part of the job. That's not necessarily workplace misconduct. I mean, I guess it depends on how you define it.
It could be, although I mean, it that could be. It's not. I suppose that being on time to work every day could be part of your performance plan, but it's not necessarily. And so, being late, misusing leave one way or the other, something like that could be examples of misconduct. And
Yeah, so if I'm a federal employee, how do I find out? First of all, I'm assuming they have to give me some kind of notice that I am being, that they are taking action against me under these statutes. How do I find out, and what do I need to be looking for?
So the first thing that happens almost always is that there's an investigation. If it's an example of misconduct, there'll be an investigation, and typically there'll be some agency official will be assigned as the investigator and will interview the key witnesses. Almost always the employee at issue will be interviewed to get their side of the story. I think it would be somewhat suspicious if they were not.
Yeah.
Especially if it's an incident where, so the employee is alleged to have said something offensive or threatened another employee or committed an act of violence or something where it's a sort of just a he said, she said, or, kind of situation. You'd expect the employee at issue to be questioned. And the investigator will, collect any relevant documents, emails, things like that, and then provide a report to the proposing official.
Let me back up. Let me back you up just 1 second. So,
Okay.
but if they're going under 75, if they're going, I mean, can they start their investigation? For example, like in the criminal conduct context, as a criminal defendant, it's certainly possible for the government to open a grand jury investigation, and you wouldn't necessarily know. They don't have to put you on notice until you're charged. And of course, you might hear through the grapevine, but they don't have to put you on notice.
Mm-hmm.
Is it the same here, or does the government, before it starts, if it's going to take action under 75, does it have to show up and do email or give you a notice saying, hey, we are commencing this investigation, even before they interview you?
No, the employee doesn't have any right to know that. And it could be that the investigator speaks to the person who maybe filed a complaint of some kind, figures out pretty quickly there's nothing there, maybe speaks to the supervisor or whoever and says, I don't think that there's much there. And it's possible that the whole thing fizzles out right from the start.
Mm-hmm.
If an investigator is charged with investigating, most likely they would carry that through to the end, is my guess. But I don't think there's no rule saying that they have to inform the employee at that point.
So when would you know? When they show up to interview you? Or, I mean, obviously somebody might tell you that they've been interviewed, but when would you know?
Right. It could be when you are, I've known cases where the employee finds out when the investigator, emails them or calls them to schedule, or sometimes just shows up in their office and says, hey, I'd like to talk to you for a few minutes about this matter. So that's when you, very often at the start, the employee is given a notice, I should say, I mean, by a letter saying that there's an investigation, because especially if there's an incident, let's say someone is accused, one employee accuses another of making a threat, then you would expect, a letter from the employee's supervisor saying, there's an investigation into an incident, please have no further contact at this time with whoever the accuser is, something like that. So
that would be, the government can elect to do that, but there's no requirement under the statute that they do this. It's that sometimes you will get a notice that says, hey, we're commencing this investigation.
That's right, yeah.
I'm assuming the answer is no, but let's say for instance that the allegation is that you are, perpetually late, and it's clear that the government is proceeding under Section 73 because they're interviewing people and they're not putting you under a PIP. Do you have any rights to say, oh, wait a minute, no, government, this is really should be under 45 and I should have the right to a PIP and a right to kind of cure my conduct? Do you have any rights or is it completely up to the government as to how they proceed?
So for the most part, so it's up to the government to how they proceed, to answer your question. And if you were to make that kind of an argument, you would have to make that later in the process. That's a legal argument. And at this point, nothing is happening to you and nothing has been proposed to happen to you. I mean, I'm sure it feels like there's an investigation, but there's no actual punishment being made, being issued or even being proposed. And
you're still showing up to work, you're still getting your paycheck, it's all, at least on paper, business as usual. Okay.
Right. So you can't assert a right to stop them from investigating a matter. Right. That's not something that even a federal employee could do.
Yeah. Okay. So they're proceeding under 75. You were getting to this. What happens? What's the procedure as an employee? And the following question, I sound like a White House press pool reporter. Following question is, as an employee, for people who might be listening to this, like what kind of, last time in the PIPs section, we talked about early stage action that an employee can take to try to protect him or herself. What would that be like here?
Okay. So the under 75, there's, and this is true under Chapter 43 too, as we discussed with the PIP process, that once there's an investigation that's done, and the proposing official has decided that they do want to propose some kind of a punishment, they will issue a memo or a notice of proposed removal, demotion, suspension, whatever it is. And the employee has a right to get that document. That document needs to tell the employee certain things. It needs to have a clear statement of the charges against them and the different instances, the relevant facts, which are sometimes called specifications. In other words, if you've been accused of misusing leave, specification 1 will be you misused it on this date in this way. Specification 2, you've used it on the following week in this way. So you have a right, and you have a right to notice about the specific laws or regulations that are governing this. And you also have the right to an attorney in drafting a response, and a right to respond in person. And you should also be told who the deciding official will be and how to get in touch with them. And so you have a number of things need to be in that initial memo. And one of the first things that you should do, I would advise, is to have an attorney look over that notice. And if you have an attorney represent you, very often you can ask for an extension of time, because they don't always give you that much time to respond. And they will almost always, I've never had them deny that, because they like to show that they are giving the employee sufficient opportunity to respond to the charges. They're giving them due process. And one thing that you or your attorney should do is request what's called the documents relied upon. And what that means is you have a right to ask for and to get all the documents that were used in or relied upon by the proposing official in drafting and proposing this proposed action. So that could be your time records or emails, or if there is maybe there's a transcript of an interview with someone, whatever it is, depending on what the alleged misconduct or poor performance is, you have a right to all of those documents when you're drafting your response.
And I would note that this is another area where there is a significant difference between federal sector, if you're a federal employee, versus private sector, right? Private sector, they can do an investigation, they can make a decision, they don't have to give you squat. They can fire you right on the immediately, and you can say, they're not even required to give you a reason. They can just say, a lot of times they will, but a lot of times we get people that will call and say, hey, I was fired and they didn't even give me a reason. And that is perfectly legal. So just as an aside, these are rights that it is a significant right to have, be able to get access to the documents they relied on. Private sector, no dice. You can ask for them, and the employer may elect to give them to you. Chances are actually that they won't do that. Let me ask you this, and we could do a separate episode on this because I know it's a really meaty subject. But what about your, for example, again, looking at private sector, you don't have a Fifth Amendment. You don't have a Fifth Amendment right, at least is in regards to your employment, not to speak, right? Like if they call you in private sector and say, hey, we think you had your hand in the cookie jar, you can decline to answer, but then they are perfectly in their rights to fire you. How about here? Somebody, let's say the first time you find out you're being investigated under Section 75 is that HR calls you and says, hey, we need to talk to you about this, alleged, sexual harassment. What's your right? What rights do you have to answer or not answer?
Well, so one thing to be concerned about if you're being investigated is my advice would be to tell the truth and to do it fully, because because what could happen is if you give maybe a partial answer, leave things out, even if you don't exactly lie, or if your answer is somehow misleading, you open the door for the proposing official, for the investigator could say, during the investigation, the employee did not fully answer the questions. And then the proposing official could propose an additional charge against you, which is lack of candor during an official investigation.
Andrew McCabe, right? Andrew McCabe.
Right. Yeah. No. In places like the FBI, the Department of Justice, generally they take that very seriously, and just generally, you want to make sure that you don't harm yourself even further by giving the agency an additional reason to take an action against you. So that would be, when I represent people and they are going to undergo an investigation, and sometimes they're allowed to have attorneys with them during these investigations, I advise them to be completely honest and open. You do not want, and also because you don't know what documents or evidence the investigator has. They might be speaking to you first, but very often they speak to the employee last, after they've spoken to everyone else, after they've done their document review. And so you don't want to be caught telling less than the full truth.
Right. Yeah. And so I guess in most of these cases, what we're talking about here is where you don't have criminal liability. Like this is different from the Office of Inspector General, which also conducts investigations that comes in, and most federal agencies have one that come in when there is wrongdoing or some kind of criminal wrongdoing. Those are different sorts of investigations.
Yes, that would be a different kind of thing.
Yeah.
In this kind of thing, I mean, I suppose you could be charged with, there could be an argument that you have, or a claim that you have misused government funds, something like that, that does that would be a crime. And in that case, I think it would be, you could invoke the Fifth, but that could not be used against you. But it would only be in circumstances like that. For the most part, you want to be as open as you can when you're answering these questions.
Well, and this gets to my next question, like when in the process, and I know because you and I are attorneys, we tend to lean toward as early as possible. When should one get an attorney?
Well, I think it wouldn't hurt to meet with an attorney as soon as you see that there's an investigation starting into you, or when you first suspect it, because an attorney can help you prepare for how to answer questions in a way that is completely honest, but still, but gives you the best chance, presents your case in the best light to the investigator.
And I think just to quite the issues we were addressing earlier, when there is, and in most cases, where there's this wrongdoing charge, there isn't criminal liability, but there are some very complicated and fuzzy lines about, workplace investigations that do involve potential criminal liability, because, once you've talked about that, then you can't later, invoke the Fifth. Once you talk to the investigator and let's say they reach a conclusion that you did have your hand in the cookie jar, that you were stealing funds, they could make a referral to the inspector general. But anyway, these are all things that you should talk to with full candor with your attorney, who can then advise you about how to best assert your rights, because there are some competing interests here. One is, which you addressed, the important to be have complete candor with during the investigation. And the other is your need to protect your Fifth Amendment rights, which granted are a smaller number of cases. Most workplace misconduct charges, investigations don't involve criminal liability. And then you're best advised to, give a fulsome response and don't hide anything, all the good, bad, and the ugly. So anyway, just another plug for seeing an attorney early on to make sure you know where that line is.
Yeah, that's a good point. For the most part, criminal issues, most employees who have these charges or investigations against them don't have to worry about potential criminal actions. But if you do, I would definitely advise you to talk to a lawyer. I'm both a criminal lawyer and an employment lawyer.
Yeah, and they have to give you we'll have a separate episode on this, but they have to give you specific kinds of warnings, as a federal employee, if they think that, if there is criminal liability. So it's not that you usually have some heads up that that's where the government is going, but we'll address that one at another time. Okay, so whether you have an attorney or not, an investigation is completed, and then just pick up where you left off. What happens?
Okay, so when it's completed, the investigation, the completed report, which the investigator will draft, goes to the proposing official. And that official reads it and then decides what, if any, action to take. Now, it's possible that the proposing official decides to do nothing. And if the official has told you that there's been an investigation, there may be you may get notice that the investigation is concluded and they're not going to take any action. But very often there will be some kind of action proposed, and it could be anything from removal to a suspension. I guess the lightest punishment could be something like a letter of reprimand in your personnel file. But if there's an investigation going on and a formal proposal issued, it's probably going to be something, at least a few weeks of suspension without pay for the employee. And like I said, when you get that notice of proposed action, I would go to a lawyer and review it, and your lawyer can help you talk about how to respond. And when I represent people who are in that situation, it's important to know what the laws are that are governing that the particular charges that the employee is facing, what the particular rules are. One thing that every agency should have is a table of penalties, which list various infractions and the standard punishments that are issued for a first offense, second offense, third offense, and that's something that would be one of the documents relied upon that you'd want to see, just as an example. But a lawyer can be very helpful because he or she would have access to MSPB case law about how these different, which allow the attorney to make all different kinds of arguments about the notice of proposed removal. There's various issues, maybe the charges are not sufficiently clear. For various, depending on the different kinds of charges, there are different arguments that we can make in response. And very often, though, even without getting into legal technicalities, one important service that an attorney can provide is just drafting a narrative, a statement of what happened from the employee's perspective in a way that is persuasive and shows that they are not at fault. Or if they are at fault, admitting it, but putting it in a light that is more favorable to the employee and explaining why that, the infraction was minor and doesn't merit being demoted or whatever the proposal is.
And remind us you mentioned the MSPB, what that is, and when you say MSPB case law, why is that important here?
Okay, I'm sorry. Okay. We had talked a little bit about this, I think, in the last podcast, but the MSPB is the Merit Systems Protection Board, and it is the agency that basically oversees adverse actions. Any suspension more than 14 weeks, any demotion or termination is going to be covered by is going to be appealable to the Merit Systems Protection Board, where an administrative judge, MSPB administrative judge, would hear the case and issue a decision. And so those decisions are published and attorneys have access to them, and they can be very helpful in opposing or responding to a proposed action.
You mentioned the 14-day limit. Why is that important?
Well, so it's important because if you're suspended if the proposal is or if there's ultimately a decision that is made after the proposal, there is the employee has the chance to respond. After the response, the deciding official, who is different than the proposing official, makes a decision about what to do. And if the decision is a suspension of more than 14 days, or an action like a removal or a demotion, then that decision is appealable to the Merit Systems Protection Board. If it's 14-day suspension or less, then that action is not appealable. Basically, they just draw a line and they say it's not worth having a whole case with attorneys and an administrative judge over anything less than a 14-day suspension without pay. But even and agencies are aware of this, and sometimes they will make a decision suspending an employee for exactly 14 days because they know that that's not something that the employee can appeal. There's just that's it. That's the end of the process if the decision is a 14-day suspension. So that's the importance of that.
So it sounds like this response to the deciding official is sort of a critical moment, because it is possible, if you present your case well, that there will be no action, or at least not an action beyond the 14-day suspension.
Right. Yeah. And I sort of jumped a little bit ahead of this talking about the MSPB, but that's right. That you could resolve the entire thing. The deciding official, after reading your response, could decide there's just not enough here to support the proposed action. Or the deciding official could decide, well, there's some misconduct here, there's some evidence of poor performance, but I don't think that it merits demotion or removal. I'm going to suspend this person for a couple of days, and that's my decision. And so, and which, if you're facing termination, being suspended for 2 weeks, that's not bad. Yeah. If you're worried about, possibly losing your job altogether. So one thing that another aspect of this process, we talked about the MSPB and their decisions. One important decision is called Douglas, because it listed these 12 factors, which are called Douglas factors. These are factors that decided that the agency basically has to take into account when they are issuing some kind of punishment against an employee. And they include things like the nature and seriousness of the offense, its relationship to the employee's positions, duties, responsibilities, the employee's job level, past disciplinary record, kind of common sense things. But they are an employee or his or her attorney, if you're aware of these Douglas factors, can address them in the response in a kind of organized way and say, look, this employee had a spotless record before this. This employee is not a high-ranking, public-facing kind of employee. So this incident, it does not harm the agency. This person doesn't need to be fired for this. There's no reputational harm to the Department of Justice. This person is just a low-level person. This issue did not reach the public. Also, talk about the potential for the employee's rehabilitation. This will never happen again. The employee has said that he or she, is sorry for this incident. Things like that. And is an important thing to address. It's something that the proposed, the notice of proposed action would probably address at least some of the factors, and the employee or his or her attorney should definitely address them as well.
Yeah. Okay. Is there a difference in the way, if somebody is being, pursued by the federal government, their employer, under 75 versus 43, is that right? 75 and 43? Did I get the numbers right? All right. Mm-hmm. 75 and 43. Are there different ways of thinking about, if I'm the employee, what are some key things that I need to be thinking about that would be different? Like if I'm under 75, I should handle it this way. If I'm under 43, I should handle it this way. Is there any strategy to think about?
I think that it's so 43, like I said, at the point that an employee receives a notice of proposed action under Chapter 43, they've already been through a PIP at that point. And so what they're going to be arguing, the arguments that they're going to put forward in their response are going to be based on issues like, did they receive proper notice of their poor performance? Did they get an opportunity? Was the PIP a real meaningful opportunity to improve their performance? And they should have a lot of the records and basically all of the necessary records they should have in their possession at that time. Now, under 75, it's a little bit different. They may be, the employee may be learning much of this for the first time. And so the notice of proposed action and obtaining the documents relied upon is, which is something they have a right to under 75, is very important. And this is their first chance really to respond and to, although there's been an investigation where they perhaps given a response there, this is their first opportunity to really formally respond in writing and tell their side of the story, and to bring forth any evidence maybe that they have that supports their case. Because in a misconduct case, there may be various pieces of evidence that the proposing official didn't know about. Maybe the investigator didn't ask for, didn't have, and a lawyer can help you figure out what evidence you might be able to potentially obtain and use in your defense. So those are important things. And I think reading the document closely to understand exactly what you're being accused of and what the support for that is an important thing with a Chapter 75. Under a 43, you already know it's poor performance, and you may not see, and most of the, if not all of the records that would be used by the agency to support that action, you probably already have, because it's probably emails to you, the employee, saying that you're not working hard enough. Maybe it's a midterm review, end of year review, the PIP notice, all of that stuff. Whereas in a 75, if you have maybe an email or some document showing that you were not, let's say, even at work or in the office at the time that you're accused of stealing or whatever the case may be, it's that kind of thing could be an important piece of evidence.
Yeah. So it sounds like the 75, it's much more back-end loaded, at least from the employee's perspective. Like with under 43, there's a lot more interaction with the government. You're on a lot more notice. You're kind of integrally involved with the process, whereas under 75, the government's doing their investigation, and then you might probably, but you may or may not get interviewed, but you only learn about it once you get this notice of proposed, or you only get really the goods when you get this notice of proposed action.
Right. For example, I represented someone who just had a conversation at work, but nothing formal, with their supervisor. And their supervisor, and then later they got a proposed removal based on things that they said during that interaction, and they hadn't, been interviewed about that. Their first notice of that there was any, hint of trouble was getting that proposed that notice of proposed removal. So.
Is transfer an option, where you would keep your same, benefits, your same salary, but, the government says, hey, we don't want you in this department anymore. We're going to move you over here. Is that ever an outcome in these sorts of proceedings, or is it you either keep your job or you're out, or there's some kind of suspension?
So if there's an action like this being taken, it's, I suppose that's something the employee could do, is to say, is to maybe put in a request for a transfer and then notice in their response, I've done that. But basically, you're being accused of misconduct or poor performance, and you have to address that on its merits. And you'd have to explain why the transfer, maybe you would have to explain why the transfer would resolve the issue or ameliorate things. It might be relevant there, but for the most part in this process, they're concerned with what the charges are and what your response to those is. And so maybe a transfer could help explain why a reduced penalty is it could be support for an argument that you should not fire me. I put in in for a transfer. If I move to a different supervisor, you have to explain why that would be a plausible thing.
So this would have to come from the employee, like you said. It's not, the government's not going to recommend this. This would be something that if it was, for instance, like if it's a dispute, if the allegations involve a dispute with a coworker, and you can say, hey, you know, first of all, whatever, I dispute whatever was said about me in this dispute, but nevertheless, I put in a transfer, and if I transfer, then that would take care of the situation because otherwise my performance is very good. That would be sort of the way you'd approach it.
Right. Well, so I mean, there are times when the agency is motivated to do that. If there's been an accusation like this, they don't want any further problems. It's nice. The government is big, and it can often easily move people around, and so it will do that if it wants to. But if it doesn't, then I suppose, like I said, the employee could request a transfer and explain why that would resolve the issue. But if it's a situation like you're describing, then very often, in my experience, the government will take some action to separate the employees if it's possible, and to keep them. If it's not possible to transfer them, then to prevent the employees from being in the same place at the same time, if at all feasible.
Got it. So, and getting back to 75 and to 43, I guess to the extent that there is a process here, and there obviously is a process, there's no hearing in the sense that like there's going to be witnesses called. This is all on paper, right? Like you get the notice of proposed action, you can respond to it, attach your own evidence, but it's not like you get to go in, been on the stand, hold your hand up and get, right? There's none of that at this point.
Right. Although you do have the right, as well as responding in writing, you have the right to respond in person as well. And that can be a very useful thing, especially in a Chapter 75, because if it's an allegation of misconduct where maybe some coworkers accused you of doing something, it's helpful to have the employee, and along with his or her attorney, I would advise, go to the meet with the deciding official. The employee can then tell his or her side of the story after meeting with a lawyer first to make sure things go smoothly, and then ask the deciding official, are there any questions you have? Are there any problems or issues that you have? And so it can be a very useful thing. Sometimes the deciding official is not especially interested, has already maybe made the decision, but sometimes they will ask a lot of questions, and it can be useful, because in a written response, you don't necessarily know. You can't respond directly with the particular concerns that the deciding official has, whereas an in-person oral response allows you to do that. So it's not a hearing, it's not a trial, but it is something that you should prepare for, and I think in a lot of cases it can be a good thing to do. Also, you can, as a kind of strategic issue, even if you're not interested in doing them, if you're worried that you're going to be fired, asking for an oral response and putting it out as far ahead, scheduling it as far into the future as you can be a way to kind of delay the decision possibly. But that is if you're just, if you basically think the fix is in and you're going to be fired no matter what, it's a way to buy more time.
Yeah. And that is an automatic right to do both? I mean, obviously you got the right to do in writing, but you have a right to do both. You get to elect. I mean, you get to.
Yes. And so what I tell clients is that, when you submit a written response, always elect to give an oral response as well. And then later, if you don't want to do it, you can always say, I'm gonna opt not to. But in your written response, you should indicate, I also would like to do an oral response.
And is that how it works? Are there any forms? Is there a box to check, or you just got to, on your own, when you were submitting your response, say, I would also like a chance to do this orally?
Right. There's no form. I put it at the end of my response.
Okay.
And the notice should tell you that you have a right to it if you so choose.
I think.
Mhm.
But is that always, you always have the right, or does it vary by agency?
You should. I don't know of any case when you don't, and I believe you. It's in the regulation that you have a right to respond orally to these charges. And as I said, agencies like to. They bend over backwards to give the employee at least the appearance of due process. So if you ask for an extension of time to file a response, they'll almost always say yes. And if you ask for an oral, an opportunity to speak in person with the deciding official, that's something that they're going to do.
And with the deciding official, when you have this meeting, is it usually, I mean, it sounds like it's fairly informal. I mean, that the deciding official can ask questions or not. I'm assuming they don't have counsel there. Like it's just, your deciding official sitting in the office, listening to what you say.
There can be a lawyer there. Often it's an HR person.
Mm-hmm.
And very often things that the employee says or things that happen in the oral response do show up in the deciding official's decision.
Mm-hmm.
So it's something that, it's something that can affect the outcome.
Do they record it, or is this usually no?
They typically do not record. They can, and I've been involved in a few where they have, but for the most part, they don't record the those meetings.
Should the employee request a recording?
I don't know that it would be. It could be relevant in the so if there is a transcript, the way that the employee would get access to that is if they don't like the decision that's been issued, and they file an appeal to the MSPB, they could then they then have an opportunity to engage in discovery. And there may be documents that were not part of the documents relied upon that I spoke about before, but that are relevant. And things that were said in the oral response that were part of the basis for the decision, that could be one example of the kinds of documents that you would be able to get in discovery in the MSPB.
Yeah, I'm just wondering, to protect the employee, because it seems like it would be if you're just in a room with the deciding official by yourself. I doubt that they would do this, but what would stop them from saying, well, he just admitted to the whole thing. So, thanks, and you said, no, I didn't say that at all. And then you've got a dispute about what was said, in your oral presentation.
Yes. That would be a difficult thing. Unless if it were absent a transcript, it would be hard I would think, for the agency to do that. If you've filed a response saying, I did not say that, for example, and then and if all that either party has to rely on are their notes of the occasion, then I don't know how strong, how much evidentiary value that would have before an administrative judge. I think the underlying facts of whether you actually did it or not would probably take precedence over a dispute with with the deciding official over whether you said what exactly you said during that meeting that wasn't recorded.
I see. So it's not necessarily going to decide it for you one way or another. What deadlines do people need to be concerned about? Like, for example, like once you get the notice to propose action, does it vary in terms of how long you have to respond? Is there a statute? What's the rule?
The rule is 30 days. So the rule is 30 days in order to issue a response to the proposed decision. Now, if I think for lesser charges, they might not have to give you 30 days, but if it's going to be more than 14-day suspension that's being proposed, they have to give you 30 days. And again, that can be extended just by emailing the deciding, often the notice of proposed action should include contact information for the deciding official or whoever it is that you're supposed to get in touch with about these kinds of things. And if you need an extension, or if you have any questions or want the documents relied upon. And so you can get in touch with them about that.
Okay, and then 30 days is like the deadline to get your response in, or is that the deadline to give them notice you're going to file a response?
No, that's the deadline to file the response.
Okay.
Because, yeah, and I would, if you're not going to file a response, I suppose you could just tell them, I'm not interested in that at all. That seems like probably a bad idea,
Right,
unless you're willing. I mean, maybe it's a suspension. You're willing to accept the consequences, and you don't want to fight it. That's your decision.
Yeah.
But if it's more serious and you're talking about maybe getting a lawyer for this, then yeah, you're going to be filing a response, and it's due in 30 days. The notice, it's not just the notice that's due.
The actual response, because I know, like, in appellate work, you give them a notice of that you're going to elect your right to appeal, and then you get a briefing schedule and all that. That's
right.
That's,
it's not like that.
Got 30 days to actually get the final document in, unless you ask for an extension, which you noticed you indicated was readily granted. Okay, so then you have 30 days to submit your notice. At what point, we're going to have a separate show on the MSPB. But when do you get there? How does that work?
Okay, so after you've responded to the proposed action, the deciding official has an opportunity to review the proposal as well as your response, as well as speaking with you in person. And if there's any additional information that comes to light during this time, you will have an opportunity to respond to that as well. That I haven't known that to happen, but that's something that could happen. And then at some point, and it can vary how long it takes. There's no deadline for the deciding official. They could hold on to this for months before making a decision. They could decide very quickly, but they issue you a written decision. And if you have, and then this decision would have in it your deadline to file with the MSPB, and that's the next step. So okay. Once the decision is issued, you're not dealing with the agency, your employer, your employed, the agency that employs you anymore. You're appealing this to the MSPB, where an administrative judge is going to make a decision. Okay,
very good. Well, I think that covers most of what we were going to talk about today. Anything else I forgot to ask you, or you want to add about how agencies proceed under Section 43 and 75?
No, I think that's about it. I think after the MSPB, you can then file in federal court. If you wanted to elevate it to that level. So that would be the next step after that. But otherwise, I think that's basically it for misconduct and other kinds of actions under 75.
Okay. So all right, just in sum, for those for those folks using the transcript here, so we've got Section 43 and 75, which basically cover the ground for any kind of workplace misconduct, which includes everything from performance related to your work and other kinds of alleged wrongdoing, for example, criminal activity outside of work. And there are different procedures in the way that the government proceeds under 43 and 75. And as always, we recommend earlier rather than later, you should get a lawyer, because there are a number of points in both of these processes where you have a chance with effective advocacy to essentially change what the agency might do and save yourself a lot of headache and trouble from even getting to the MSVP in the first place. So thanks again, Rob Porter. We will do our next one on the MSVP and how that agency works and what to do when you get there.
Thank you. This was fun.
All right, take care.